Greetings of the day to Madam Ashikin. Today, me and my fellow friends will be presenting to you the procedure to commence an appeal under Order 55, Rules of Court 2012. So, without further ado, let me introduce my group members. Today, we have Liana, myself, Jayashri, Jessica, Asra, as well as Jaswal. Okay, moving to the introduction. So, what is appeal? Appeal is basically like a request from someone who feels unsatisfied about a court's decision that they have tried. So what they do is they ask the higher court to review the judgment that was given in the lower court and to request in the belief that the lower court has made a wrong judgment about the case that they have taken action towards too. So what are the laws that are applicable to this appeals includes the subordinate court rules under 1980, and then we have Rules of Court 2012 as well as Courts of Judicature Act 1964. Moving forward to the grounds of appeal. So, under Order 55 of the Rules of Court, they have list a few valid reasons for filing an appeal. So, these reasons include mistake in applying law. For example, if a particular case does not apply that particular legal principle, then that would be an error of law. And then we have procedural issues that affects fairness, and even newly discovered evidence that would not be tried in court. So all this could be reasons to grounds of appeal. And if someone believes that the facts of the ground in the original case is unreasonable or not supported by the evidence that has been submitted, then they may also appeal. So the purpose is to make sure that these appeals have solid and fair reasons, maintaining the legal process integrity and upholding the justice. Moving forward to the time limitation. Okay, so under Rules of Court 2012, it states that if you want to make an appeal to the decision made by the High Court, you must do so within 1 month from the date of the High Court pronounced this decision. So you need to submit an appeal at the registry of the High Court and then where the decision was announced. And then if you are the party responding to the appeal, then you may argue that the High Court's decision should be changed. So you can express this intention at any time during this process, but it should be done within 1 month. So and also within 10 days, you need to it is instructed that within 10 days of receiving this record of appeal, a party should provide a cross of appeal. For example, this notice is actually for the appeal, and it should detail the reasons of cross of appeal and why it must be filed to the relevant parties involved in the particular case. So an example case can be seen in Song Ken Hiang, where they said that an overlook. So this party appealed for the case, but they overlooked the date for serving the notice. But then the court refused. However, the court has the discretion to extend the time, but you must have solid reasons and evidence. And another case is Bhagwan Singh and Wong Sing Chong's case, where if there is no grounds of judgment in a particular case given, then it does not stop that person from appealing to the higher court to move forward, appealing to the higher court for a decision. So these are all the example of cases that we could find. I'll pass it on to the next team member. Thank you so much.
Hi, Assalamualaikum. My respectful lecturer and my group mates. My name is Asra. So I will present on case law. So the first case law is Sulaiman bin Muhammad was Melayan banking. So the facts of this case is the applicant contended that so the facts of this case is the judgment sum less than 1,000 still proceed with appeal under section 28 clause 1 1964. So that health is appellant intending notice of appeal from form 140, but learned counsel failed to do an application dismissed. So the second case is Lee Len was Lim Yun Noi. The defendants appealed to the High Court for the extension of time to serve the notice of appeal, and this was allowed. After that, the plaintiff appeal, the time limit to serve the notice of appeal is 14 days from the date of judgment. So the proper form to apply for extension of time is the court appeal, which is from the magistrate court in this instance. So the court held that, however, the application for extension of time could also be made by High Court, although the court would discourage such practice. In this case, there was a proper application for extension before the High Court. So the third case is Muhammad Mustafa was Kandasamy. So it was held that the court was unfettered discretion to the grant stay, but such discretion must be founded upon the established judicial principles. So one of the determining factors that call for consideration is whether by making order for stay of the execution, it will be made the appeal if successful. Negatory in that it will be depend and appellant the results of appeal. How pertinent that factors will be made according to the circumstances of each case. Next slide, please. Okay, so however, the rules in appeal is the rules in appeal from subordinate court to the High Court is the first one is appeal from any decision made after trial, which one is Order 55 Rule 3 Clause 1 until 6 Rule of Court. And the second one is appeal against any decision other than a decision made after trial, Order 55 Rule 5 Clause 1 until Clause 3 Rule of Court. So the last one is under extension of time rule. There are three, which is Order 3 Rule 5 Clause 1 and Order 3 Rule 5 Clause 2, Order 3 Rule 5 Clause 3. So that one is the period within which a person is required to serve, file or amend any pending in other documents may be extended by consent in writing with the order of the court being made for that purpose. So the exceptions, the first one is Section 26, Code of Judicial Act 1964. This section is pertaining to appellant civil jurisdictions. The second one is Section 28, Clause 1, Codes of Judicial Act 1964 stated subject to any court, any other written in law, no appeal shall lie to the High Court from decision of subordinate court in any civil cause or matter where the amount in dispute or the value of subject matters in 10,000 ringgit or less, exceptions except on a question of law. So the third one is Section 28, Clause 2, stated that appeal shall lie from any decision of a subordinate court in proceeding related to maintenance of wives or children, irrespective of amount involved. In short, the sections above mean amount in dispute or value subject matter is around RM 10,000 or less, then no appeal shall lie unless the matter involves sections of law or written law. In last section 73 Codes of Judicial Act 1964 stated that regarding appeals or not operate as stay of executions, its appeal not operate state of execution proceeding under decisions appeal unless court below of Court of Appeal so order had no intermediate proceeding shall be invalid except so far Court of Appeal may direct. So that's all from me. I will pass to next presenter. Thank you.
Okay, thank you so much, Asra. So, very good day to madam. My name is Jessica. So now I will present you for the part of documentation. For the first one is notice of appeal. So this document formally notifies the court and the other parties involved that you intend to apply the decision. So it typically includes basis case information such as the court name, case number, date of judgment being appealed, and the specific reasons or grounds for the appeal. And then for the second one is the court forms. So the court forms, different jurisdictions have specific forms required for initiating appeal. So these forms gather essential information about the case, such as the names of the parties, case number, and details about the judgment being appealed. And then for the third one will be the grounds of appeal. So this document outlines the legal basis for the appeal. So it details the errors or issues believed to have occurred in the lower court decision and explain why the decision should be reconsidered by the appeal court. And then for the last one will be the certified copy of the judgment and order. So I will move to the next one. It will be the summary. So the summary of appeal procedure to the COA is we should have 4 copies of notice of appeal in Form 1 of rules of Court of Appeal to be filed at the registry where the decision is appealed from the sum of 500 ringgit to be lodged as security for cost. So serve notice of appeal on the respondent within the time limited for appeal. So it will be 1 month. And then for the second one, send a copy of notice or appeal by register post to the registry of the COA and then COA. And then the third one, file 4 copies and serve the appeal record within 8 weeks from the date of filing the notice of appeal. So if this could not be achieved, so they could they follow practice direction 1 of 1996, And then the fourth one, filing fees for notice of appeal will be 300 ringgit. And then for the last one, filing fees for record of appeal with the memorandum of appeal will be 50 ringgit. So that's all from me. Thank you so much. I will pass for the next presenter.
Very good day to Prof. Ike. My name is Jasper, so I'll be explaining on the problematic question. So, according to the question, Ishak sues Bala for battery and court awarded Ishak the general sum of 230,000. Ishak is not happy with the sum awarded and appeals for a sum of RM 400,000. Bala is also dissatisfied with the decision and want to appeal as he contends that Ishak is contributory liable for the battery. Bala cross appeals for a sum of RM 300,000. Explain as to Ishak's and Bala's appeal. Next slide, please. So, the legal issue that associate with this case is whether Ishak and Bala appeals complying with a battery lawsuit whereby the court granted Ishak RM 230,000. Bala cross appeals arguing which Ishak is controversially culpable for the offence and which is seeking a lesser payment of RM 300,000, and Ishak's appeal for greater sum of RM 400,000. Next slide. So the rule in this case would be there is a concept of battery which entitles deliberate, hurtful, or offensive touch. Damages is granted in battery cases are aimed at compensating the victims over the injuries sustained. For battery, is the unlawful use of force on another individual or their personal item resulting in bodily or offensive contact. A battery is an attempt in an assault. A battery is a general purpose of felony, does not require any particular mens rea. To defense violence, the defendant must demonstrate that they got the plaintiff agreement or acted in the defense of others in addition to self-defense, regardless of whether the defense is merely a reasonable assumption and not relative. So, according to the section 352 Penal Code, whoever attacks or utilizes criminal force on another person other than upon serious and unexpected provocation offered by that person will be penalized with the imprisonment over a term of up to 3 months or fine up to 1,000 ringgit or both. Contributory responsibility is a concept in a law that considers how much a plaintiff committed for their own damages and may influence the quantity of damages awarded. So that's all from me. I would like to pass to Diana.
Thank you so much, Ashbal. So, madam, my name is Nurul Zindiana binti Idris. For the application, in order to apply this case in Ishak legal action against Bala, the allegation of battery must have the strong proof or reckless physical contact lacking concern mirroring the essential components of the tort. For example, the case of Tyne versus the case of Tyne against Lee, where the court underscored the significance of the intentional contact dividing of concern as the foundation aspect in establishing a claim of battery applied to Ishak accession against Bala. Element of tort automatically will be included when it comes to battery, where it have the duty of care. In the context of Bala battery against Ishak, it shows a breach of duty on to prevent unwarranted physical contact. For example, the case of Ali against Rahim, where the court upheld a similar duty of care to prevent physical harm. Furthermore, the breach of duty shows the failure to fulfill legal responsibility when Ishak claim rests on proving Bala's breach of duty to avoid harmful or offensive contact, intentional in battery cases. For example, the case of Lim against Kong. Finally, in this case, it also have the content of evaluating battery essential and the resulting harm or offense. So in the case, the courts that cost RM 230,000 aim at the compensating the harm caused. For example, the case of Raj against Tyne, where the damages were awarded with the harm's nature aligning with this case. For the conclusion, next slide. Ishak and Bala appeal over damages assessment and Ishak rules in battery, applying the Malaysian tort law for liability and damages. Thank you so much, madam. That's all from us.